Hi, welcome to the Healthy Family Law Attorney. I'm Tom Marks with the Marks Law Firm in Orlando, Florida. And today I'm going to answer a question from a viewer. I received a question that says, I don't want anything to do with my spouse. Can I waive child support so I never have to deal with him or her again? Okay, well, interesting question. Let's start off with first, child support is a matter of public policy in the state of Florida. The state of Florida believes that if able-bodied parents do not pay their child support, it is more likely that the recipient spouse, let's say the mother in this case, won't have enough money to raise the kids, to provide for them. The mother in this case would more likely become a welfare recipient. And of course, the state of Florida doesn't want to unnecessarily have to pay welfare. So that's the public policy. If there is an able-bodied parent that has a job or should have a job, they should be paying child support. And so technically, you're not supposed to waive the child support. Now, let's back up a minute because I've got a couple of other things to say about this, and there are ways around that, believe it or not. But first of all, if you have minor children with someone, it's kind of hard to imagine you're not going to have to deal with them in the future because you have children together. There's going to be a parenting plan, there's going to be time sharing, there's going to be drop-offs and pickups, there's going to be school events, birthday parties, summer vacations, all that. The only time that you really would never have to deal with your former spouse is if there was a TPR, which is a termination of parental rights. That does happen on occasion. It's fairly rare. You have to have good grounds to do that. But yes, if you were able to terminate the parental rights of your former spouse or the parent of your child or children, then yeah, there would be no child support and there would be no contact and they would have no rights with regard to the minor children. So let's assume you're going to have to deal with them to some degree with regard to the minor children, but you've decided you don't want anything from them. You don't want to receive child support. You don't want that hassle. So let's look at how the child support guidelines are calculated. You look at the net income of both parties. You look at the number of overnights awarded to each of the parents. You look at the health insurance, the amount paid for the minor children, and finally the daycare or before school or after school care that's paid for the minor children. And all those are factored in. So there are ways of adjusting the child support and perhaps getting to zero based on adjusting those numbers. So let's look at some ways to do that. And before I even get there, I can tell you that there are cases where I have seen that no child support guideline worksheet was ever filed with the court. Now, statutorily, it's a requirement that whenever there are minor children, you have to provide a child support guideline worksheet. But I've seen cases where it wasn't filed and there was either an amount different than what the guidelines would have said, or there's no child support paid and nobody questioned it. The court did not act on it, did not request it, did not require it. So that's one way to do it. Don't file a child support guideline worksheet. Not something I typically recommend to my clients, especially if they were going to be obligated to pay the child support, because here's why. If the judge catches it and kicks it back, kicks the final judgment back, so you're not getting the divorce or you're not getting the final judgment of paternity with the zero child support because the judge is saying, where's the child support guideline? You may have reached an agreement with your former spouse or the other parent to agree on zero child support based on some time sharing that you gave up or something else you gave up. And then the judge is going to kick it back and make you pay child support anyway. So it's a risk to the payor spouse. So let's look at some other ways to adjust the child support guidelines. Sometimes the other parent is willing to pay for things like private school tuition. And we can tell the judge, that the other parent's going to pay private school tuition in lieu of the child support. We could include it, the amount of the private school tuition, into the guidelines, into the section that calls for before or after school care or daycare. And typically a judge will be okay with that. It's not technically daycare or before or after school care, but it does involve the children's welfare, best interests, and schooling. So judges will do that. Sometimes we can adjust the child support downward and get to zero by including unreimbursed medical expenses, prescriptions for the minor children. And if that number is large enough, even though, let's say, the former husband or the other parent owed $500 a month in child support, if it was included on the child support guideline that that parent was paying a certain amount of unreimbursed medicals or prescriptions for the kids, then it could adjust the child support down to close to zero or zero. I will say that if the child support guidelines call for child support of $50 or less, thereabouts, typically the judge is not going to be worried about you putting in the final judgment no child support, because the guidelines called for such a small amount of child support anyway. Okay, another way to adjust the child support guidelines is when we have to impute income to one or the other party. Imputation of income is basically saying, if that parent was working, this is how much they could earn. They might not necessarily have a job or be earning anything, but courts often use imputation of income to calculate the child support guidelines, alimony, other things like that. So let's say the other parent is going to owe $500 a month in child support because your income is lower. We can actually impute a higher number to you if that's what you wanted to do, and say that you were not necessarily unemployed, but maybe underemployed, and equalize the incomes and go to zero child support that way. I'm not necessarily recommending that. I think it's a very unusual circumstance where one of the parties would want to not receive the child support they're entitled to. I will say child support is enforceable by contempt. You don't really have to deal with your former spouse or the other parent, because the child support will be ordered to be paid through an income withholding order, which goes to the other parent's employment, and their employer takes it out of their pay before they receive it, pays it through the registry of the court, and the court then sends it on to you. There's a Florida state disbursement unit that takes care of that. So you're not really having to deal with your former spouse when you're getting child support. And one last thing, if you deviate from the child support guidelines, and let's say you're gonna only get $300 or $400 a month in child support, so it wasn't a big deal, it wasn't worth it to you, but then later on the other parent starts making a lot more money, and let's say you're struggling, or maybe your income has reduced and now they're supposed to pay you a couple thousand a month, that is significant. And if you don't have a prior child support guideline worksheet, it can make it a little bit difficult to show the court that there's been a substantial change in circumstance, because the statute says that the child support has to change $50 or 15%, whichever is greater. Now you can argue, yeah, anything is greater than zero child support. So there's certainly ways around that. Okay, so I hope this has been helpful. My purpose is to provide hope and help to your family to successfully navigate the family law process in a healthy way. All right, please like and subscribe, hit that bell icon, leave comments. Love to answer questions like this. I hope this again has been helpful, and we'll see you next time. Bye.